Welcome everyone. If you're sticking it out for another hour, I apologize for some repetition that we'll be having, but those of you who are just joining us, welcome. We're delighted to have you. My name is Amy Berquist. I work at the Advocates for Human Rights, which is a non-governmental organization, a nonprofit based in Minneapolis in the United States. And this training, this continuing legal education, is focusing on reporting to the United Nations Committee Against Torture on the death penalty. So that's what this training is all about. Some of you are probably parts of pro bono teams that are currently working on reports for us on death penalty issues for the Committee Against Torture. Others may be here because you want to learn more about those opportunities. Either way, you're most welcome. And we will get started. A brief agenda of what we're going to cover in this training. I'm going to give an overview of UN human rights mechanisms. Then I'll talk a little bit about the death penalty issues we look out for in our reporting to the United Nations. Then we'll talk about writing an alternative report, also known as a shadow report or parallel report. And then we'll talk about some general principles that will be useful for the reports that you're working on or for the reports you might be working on in the future. And as I'm speaking, feel free to add questions in the chat or unmute yourselves, and you can engage with us in that way as well if you want to speak. A little bit about the Advocates for Human Rights. Our mission is to implement international human rights standards in order to promote civil society and reinforce the rule of law. We have been around since 1983, so we've been doing this work for a very long time. I like to think we're pretty good at it. And in the International Justice Program, I like to think of our role as being kind of a megaphone. Our role is really to amplify the voices of our partners so that their governments will hear them. And what tends to be particularly effective so their governments will sit up and listen is to amplify their voices through the United Nations. So it's not our partners speaking directly to the government, which they do a lot, but it's the United Nations repeating their words and reinforcing their message. Having those UN officials speak to their governments can be quite persuasive. The Advocates for Human Rights has something called special consultative status. And what that means at the United Nations is we have a foot in the door where other organizations without that status don't. It means, for example, we can access the floor of the Human Rights Council when it's in session. We can hold side events on the margins of the Human Rights Council. We can deliver oral statements at the Human Rights Council. And it's not just sort of a, oh, aren't we wonderful? We can do all these things. When we are partnering with organizations that don't have this status, we try to take advantage of that status and let them take the floor to speak on their own behalf, where they otherwise would be barred from doing so. So it's really empowering for our partners, and it's really effective to have our partners from the affected countries speak in their own voices and really be heard at the United Nations. Part of our theory of change at the Advocates for Human Rights is the connection between the global and the local, the international human rights mechanisms, things at the United Nations, and change in the individual countries. In a lot of countries, and sometimes it feels like this is the case in the United States as well, you feel like you're banging your head against the wall, trying to get the government to listen, trying to get things to change. And our partners can feel that as well, that they do a lot of advocacy, they're very passionate, they're very knowledgeable, but their governments don't listen to them directly. But where they can feel heard is, again, using the UN bodies to press their governments for change. So those international human rights bodies can sometimes be very influential with governments to push them in the right direction. And then another way that the two are connected is that our partner organizations are very knowledgeable about what's happening on the ground. They can feed that information to the UN experts. So those UN experts know what's going on and know what to say, know what issues to focus on, know what types of recommendations would be most useful, and how to really push the government to do its job and respect human rights. So we'll jump in now to an overview of UN human rights mechanisms. The UN system is a little bit complex. And what we're focusing on today is the third category, which is treaty monitoring bodies. So you have the Human Rights Council. If you were here for the first hour, you heard about the Universal Periodic Review, which is part of the Human Rights Council. You have the Office of the High Commissioner for Human Rights, which is kind of the administrative body at the United Nations. And then you have other human rights bodies like the International Criminal Court, the African Commission on Human and People's Rights, the European Court of Human Rights, the regional human rights bodies as well. So it's a little bit complex. What we're talking about today is the treaty monitoring bodies piece of the UN, the international human rights system. So we'll jump in and talk about treaty-based mechanisms. There are 9 primary human rights treaties. And the one that we're going to focus on today is the one where we have upcoming deadlines, and that's the Torture Convention, or the Convention Against Torture and Cruel, Inhuman, or Degrading Treatment or Punishment. But we do advocacy on almost all of the other human rights treaties as well. It just so happens that the Torture Convention is the one that we have these deadlines coming up on, so that's the focus of our training today. And the Torture Convention is fairly widely ratified. You can see all the countries in dark blue on the map are countries that have ratified. There are 173 countries that have ratified the Torture Convention, including the United States. And so because so many countries have ratified it, it can be a really useful treaty to focus on when we look at death penalty issues, which often intersect with torture. And there's a handful of countries that have not ratified the Torture Convention, or that have signed but haven't taken the final step to adopt the Torture Convention as part of their law. In looking at the Torture Convention itself, the convention is organized by articles, and the first article, the first paragraph of the first article, is the most important because it defines what torture is. And you can see that definition up on your screen. And it's, any act that results in severe pain or suffering has to be intentionally inflicted for one of many purposes. So it could be as a form of punishment, it could be to coerce someone to confess, or any reason based on discrimination. And the torture has to either come from the government or from a public official, or with the consent or acquiescence of a public official or other person acting in an official capacity. So usually when we talk about torture, there's not really any, when we talk about torture and the death penalty, there's not any question of the involvement of or acquiescence of a public official. It's usually, directly committed by public officials when it happens. The second part, the second bullet point is relevant when we talk about the death penalty, because the definition excludes specifically pain or suffering arising only from inherent in or incidental to lawful sanctions. So if you think about the death penalty, that provision, and there's a fairly strong argument to say that provision would say that you can't argue the death penalty per se is a form of torture. And that's okay. We can still do lots of effective advocacy, but there are a lot of people who look at that language and say, well, the death penalty itself, we can't say categorically that the death penalty is torture, because the death penalty would, to the extent it involves pain or suffering, that would be arising only from inherent in or incidental to lawful sanctions. If the death penalty is a lawful sanction, then that's excluded from torture. But there are a lot of other ways that torture can play a role in the death penalty and intersect with the death penalty. So not to worry about that, but there's some structural reasons why it's important to keep that in mind. The Torture Convention also has a lot of other provisions. The country that has ratified the Torture Convention agrees to not only not engage in torture, but to prevent torture, not to return people to countries where they'd be at risk of torture. They have to criminalize torture. If somebody commits torture, they have to either extradite them to a country where they'll be prosecuted, or prosecute them themselves, and so on and so forth. You can see all the different requirements. The one thing that's really important is Article 16. And it says not only, as we see in Article 2, a country has to prevent torture if it's ratified the Torture Convention, it also has to prevent cruel, inhuman, and degrading treatment or punishment. So that's something that doesn't necessarily rise to the level of torture, but might be a treatment or punishment that would be cruel, inhuman, or degrading. And the reason Article 16 is really important is that a lot of times the Torture Convention is interpreted that even if we can't argue that the death penalty fits under the Article 1 definition, it does fit under the Article 16 definition. So Article 16 is often the catch-all where the treaty body will talk about the death penalty. So Article 16 is often sort of the hook for getting in the door to talk about the death penalty in the context of the Torture Convention, because even if it's per se not torture, it does qualify as cruel, inhuman, or degrading treatment or punishment. So that's why Article 16 can be quite important. The treaty also establishes a treaty-based mechanism, which is basically just a committee, so don't let the word mechanism scare you. And each treaty has its own treaty-based mechanism or committee, and the mechanisms, these don't apply unless a country has ratified the treaty. So those of you who are on pro bono teams now working on reports, all those countries have ratified the Torture Convention, so you don't have to worry. The treaty applies to them and the mechanisms apply to them. And each committee is made up of independent experts who interpret the treaty. So that's our main audience for our reporting, are these independent experts. They're typically law professors who do this as a side gig, using law students as their labor to do all of their reporting and things. But these are experts. And so if you attended our first training today, when we were talking about the Universal Periodic Review, in that context, our audience was diplomats. These are people representing their governments. They take politics into account and so on. And in this, it's quite different because our audience is more independent-minded, more academically oriented, and that independence is really important when we think about what our advocacy is going to be as well. And the committee has regional geographic representation. You see in the photo here, this is the Palais Wilson, which is the building in Geneva where most of the treaty bodies, most of these committees meet to deliberate and to meet with the governments. The committees have a lot of different functions, and you can see those up on the screen. The only one we're going to be talking about today is the state reporting function. But just keep in mind that these committee experts also are doing other things related to the mandate of the treaty. But what we care about most here is the state reporting process. And the state reporting process is a cyclical process. So any country that has ratified the Torture Convention agrees to go through this reporting procedure. And just like the Universal Periodic Review procedure, if you were here for the first hour's training, it's a cyclical process that sort of builds, each cycle builds on the previous cycle. So the first step in the standard reporting procedure, or the old-fashioned reporting procedure, is that the state party submits a report. They will have gone through all the different articles in the convention and said, this is what we're doing to comply with our obligations here. Here's how we've criminalized torture. Here's how we are preventing torture, and so on and so forth. So they'll prepare a report. Then the committee experts will, behind closed doors, take a look at that report and compile a list of issues. It's kind of like a menu. Here are the things we want to learn more about. They'll ask for additional information in that list of issues, or LOI. And then they'll send that to the government, and the government will say, okay, we'll give you a written response. And they'll do some looking through, like gathering information or just providing additional information that maybe wasn't in their state party report. So they'll submit a written reply. Then the government sends a delegation to Geneva for what's called a constructive dialogue between the committee and the state party, typically about 6 hours in total, where the committee experts will ask a whole bunch of questions, and then they'll hand the floor over to the government to respond to those questions. And it might be just one person from the government, might be a big delegation. When the United States participates, it's usually a couple dozen people who are there from different bodies of government there to respond, but some countries, they'll just send one person who has to answer everything, and they'll have a few rounds of back and forth questions and responses from the government. Then a few weeks later, the committee experts will put their heads together and they'll come up with their sort of outcome document of the review, which is called Concluding Observations and Recommendations. So this is the document we are really eager to see after the reporting process. What did we get out of it? What did the committee experts say? What did they say they were concerned about? And what did they recommend that the government should do going forward? And then there are several years for follow-up and implementation of the recommendations the committee made. The government is supposed to do what the committee says, and then come back to the committee and present a report. Here's what we've done with your recommendations. Here's what we've done under the different articles. So that's the standard old school reporting procedure, or the reporting cycle. All of the countries that have upcoming deadlines follow an expedited or simplified reporting procedure, which makes things a little bit easier for all of us because they're there's one fewer step in the process. And in this procedure, it starts out with the committee sending a list of issues. So the committee starts with the menu. The government doesn't have to go through all of the articles in the treaty and say, this is what we've done. The committee starts and says, we want to hear more about this, 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 and this. So we call this a list of issues prior to reporting, or LOIPR. So the committee starts with that. Then the government provides written replies to the LOIPR, and those written replies are the state party report. So they don't have to talk about everything, just what the committee says it wants to hear about. Then, of course, there's still that same constructive dialogue, that roughly 6-hour back and forth Q&A between the government and the committee experts. And then same next step, which is the committee puts together its concluding observations and recommendations in a written document, and then follow up. So it's really just a little bit simpler procedure that happens. And the great thing about the procedure is non-governmental organizations like the Advocates for Human Rights can be involved at nearly every stage. So we can try to influence what goes into the LOIPR. So we can submit a report before that menu comes out to say, hey, don't forget to ask about death penalty issues. And in particular, we're really concerned about migrant workers and that they're more likely to be sentenced to death. Can you please ask about those issues in the state party? And then that list of issues comes out. We can look at the list of issues and the replies from the state party and give another report, which is what we're doing right now. So the reports that you are doing are between step 2 and step 3. We already have the LOIPR, and we have the state party report responding to it. And so now we are chiming in to give the committee experts additional information before that constructive dialogue. We can also attend the constructive dialogue either in person or remotely. There's a chance to have a closed door meeting with the committee experts before they go into that meeting with the government delegation. And sometimes that's really helpful because the committee experts have some really detailed follow-up questions. They really want to hear directly from the non-governmental organizations in the country about what's actually going on here. We've heard in the news, is this information credible? What about this? So those are really intense briefings between the committee experts and civil society. So then the experts go out into the big room with the government, and during the review itself, sometimes civil society organizations can be really helpful in like passing notes to the committee experts or meeting with them during a break saying, you got a really good line of questioning here, but what you really need to ask about is this, this, and this. And so civil society organizations can really help those experts be their best by giving them as much information as they can about what's going on the ground. And then after the committee issues its concluding observations, civil society organizations can use that as leverage to work with their governments to say, look, the Committee Against Torture said that you need to do these things. We are happy to work with you, government, to help you do that. So the next time you submit your report to the committee, you'll be able to say, yes, we've done this. We worked with civil society. We took these measures. We ensured that, for example, people under sentence of death are not being held in solitary confinement because the Committee Against Torture expressed concern and recommended that no person be held in solitary confinement for more than 15 days, which is part of what international human rights standards say. So we can work with you, government, to make sure that people under sentence of death aren't being held in solitary confinement for more than 15 days. What issues are we going to focus on? This is going to be pretty duplicative if you attended our first session, but if you're new to the training, then I'm going to give you a brief summary of some of the issues we look out for. Not all of these issues are going to be relevant to every country, and we have a much longer training that goes into a lot more detail. But these are some common issues that we look for in all of our death penalty reporting. First is just looking at what the statutes say. What does the criminal code or the penal code say about the death penalty? International human rights standards say that the death penalty needs to be reserved for the most serious crimes. So you want to look at what the criminal code says are eligible crimes for the death penalty and see if that matches up or if there's a mismatch. What do we mean by most serious? International human rights standards say that the most serious crimes have 3 elements. First, there has to be a killing. Second, the killing has to be intentional. And third, that intentional killing has to be committed by the person who's at risk of being sentenced to death. So all 3 of those elements have to be present for a crime to rise to the level of most serious. So a crime like drug trafficking doesn't involve an intentional killing. A crime such as like the felony murder rule, there are, at least Arizona, I know, allows the death penalty under the felony murder rule, where the person could be driving the getaway car and not intend for anyone to get killed, can be sentenced to death in the United States. That violates the most serious crime standard because the person driving the car did not commit the killing, nor did they intend for there to be a killing. So that would be something that we would look at. Do all the crimes rise to that level of most serious under that standard? We'd also look at whether the country has a mandatory death penalty. Some countries require judges to sentence people to death if they're convicted of a certain offense, like all people convicted of murder must be sentenced to death. That violates international human rights standards because it's arbitrary. It means that the courts can't consider the facts and circumstances of the crime, such as whether the murder was committed in the context of prolonged gender-based violence. It also means that they can't look at the facts and circumstances of the offender themselves and whether there were circumstances in their life in mitigation that might warrant a sentence other than death. Another issue to look at under the criminal code is whether it authorizes the death penalty for people who are under the age of 18 at the time of the offense. In those cases, that also is a violation of international human rights standards. So we want to know whether under law or in practice, people can and are sentenced to death for crimes committed when they were under the age of 18. We would also look at whether the country allows the death penalty for people with psychosocial disabilities and the extent to which the criminal legal system provides accommodations for people with psychosocial disabilities who are accused of committing criminal offenses. In a lot of cases, they're not provided with those accommodations. There's a lot of coercion involved during the interrogation process, for example, and there might be discrimination in the context of the criminal proceedings and disability and discrimination based on disability in terms of how the offender is characterized. We'd also look more generally at fair trial issues that touch on the death penalty in capital cases, access to counsel, and the quality of legal counsel. Now, it might be that every person in conflict with the law, every person charged with a crime has problems getting a quality attorney, but that would also apply to people charged with capital crimes. So we would be able to raise those fair trial issues. It doesn't have to be that the issue we raise is exclusively limited to the death penalty. It could apply also to other people in conflict with the law. Similarly, if the country uses torture or cruel, inhuman, or degrading treatment to extract confessions, and those confessions can be used in obtaining convictions in capital cases, that would be a relevant issue to raise in our reporting to the Committee Against Torture. Also, we'd look at whether the judiciary is impartial, whether the judiciary considers evidence that might be torture tainted. We'd look at detention conditions and whether those either rise to the level of torture or might amount to cruel, inhuman, or degrading punishment if they don't rise to the level of torture. And those might be general detention conditions that apply to all people in the detention facility, or it might be conditions that apply just to people under sentence of death. For example, in a lot of states in the United States, people under sentence of death are kept in solitary confinement 24 hours a day. And that would amount to torture under the jurisprudence of the Committee Against Torture. So that would be a detention condition issue to raise if you find it's relevant to your country. International human rights standards also say that any person sentenced to death has the right to appeal. So that would be a topic to look at. Do all people sentenced to death have that right? We would look also at execution methods and whether they would amount to torture or cruel, inhuman, or degrading treatment. We would look at gender and the death penalty. And this is an issue we try to raise in all of our UN reporting. If there are any women under sentence of death in a country, we try to include in our reports a section about gender, women, and the death penalty. So we'll include that issue. There are also other issues related to discrimination. For example, discrimination against migrant and domestic workers in some countries. In some countries, they're more likely to be sentenced to death. They're not provided an interpreter. They're not provided legal representation. And in a lot of cases, they're in very exploitive labor working conditions. And so they may be sentenced to death for a crime that arose out of the abusive treatment that they were enduring in their work conditions. There may be discrimination against various minority groups like ethnic minorities, religious minorities, or linguistic minorities that might result in those people from those groups being more likely to be sentenced to death. or there may be discrimination against the LGBTIQ plus communities in various countries. Some countries, there's a handful of countries that authorizes the death penalty for consensual same-sex conduct between adults. In other countries, there may simply be discrimination that would result in an elevated risk of being sentenced to death for someone who's a member of that community. Another issue that we like to talk about in our reports, if we find it's relevant, is issues related to human rights defenders who work on death penalty issues. This might be lawyers who represent people in capital cases, or it might be members of civil society who are working to abolish the death penalty in the country. In some countries, those lawyers and those human rights defenders face persecution and harassment on the part of law enforcement or government officials, and we'd want to raise that issue as well, because these UN bodies, in particular the treaty bodies, feel very strongly that civil society needs to be vibrant and free to criticize the government, and in a lot of countries they don't have that freedom. They face a lot of persecution for voicing their concerns and opinions about the death penalty. This is just a brief overview, though, of the issues that we might raise in our reports to the United Nations. There is a more detailed, if you're on one of our reporting teams, you've received a link to this longer YouTube video. You can find it on the Advocates for Human Rights YouTube channel. It goes into a bit more depth about the different issues we look out for as we're preparing our UN reports. But that should give you at least a sense of what issues to keep your eyes out for as you're doing your research. Now we'll jump into writing a report to the UN Committee Against Torture and some formatting guidelines. We'd like you to do your reports in Microsoft Word. We've provided the current teams with a template to use in that regard. We always include a cover page. The Committee Against Torture doesn't have a particular page or word limit, but typically our reports are ballpark between 5 and 15 pages. Usually it's only extremely, it's extremely unusual for our reports to be longer than that. Make sure that all of your pages and paragraphs are numbered. That's an overall UN requirement. We use footnotes. And when you're writing a report, we beg you, please don't use IBIDs or supras at this stage. Please, in all of your footnotes, give us a full citation every time, because we sometimes juggle things around, move things around, and it can be a bit disruptive if we have to go back and recreate, okay, what was this IBID referring to? What was the supra talking about? So if you can please just give us full citations in every footnote, that will make our editing much easier. We also like to talk about using people first language in our UN reporting. And it's really important in the human rights world that we see people as human beings, as individuals who are rights holders, and not prioritize a characteristic that might have befallen them. We see them as people first. So we try to avoid using words like prisoners, the condemned, detainees. We try to refer to them as people in detention, people under sentence of death, people with disabilities, for example. We will also use the adjective LGBTIQ plus people, though that's acceptable. But generally speaking, we try to use people first language and avoid terms that might essentialize a person and say that the reason we care about them is because they are a prisoner. That identifies them with their conditions rather than identifying them as people first. Our audience for this report, our primary audience, as I've mentioned before, is the experts who serve on the treaty body. So we are writing to law professors and academics. These are people who are experts not in the particular country that you're writing on, but they're experts about issues related to torture. So we don't need to lecture them about what torture is and is not. We don't need to quote to them articles from the Torture Convention. They know very well what the Torture Convention says and what the parameters are for the Torture Convention. What they really want from us and what they don't have is on-the-ground information. They want to know what in particular is the situation in the country that's being reviewed, so they can be better prepared for that 6-hour back and forth session with the government experts. We have a couple of secondary audiences for our report. We certainly want the government of the state under review to read our report and see what our criticisms are, see what our recommendations are, see what our concerns are. And we also have an audience, the general public. In some cases, there's not a lot of information about death penalty issues in the country that's being reviewed. So we're compiling things in one authoritative source so that the public who want to be, members of the public who want to be educated about the death penalty and torture-related issues in the country can have a reference point, including our partner organizations. They will use these reports to educate the public, educate, lawyers, law students, but also when they're doing campaigns with the public, they'll use these reports as well. So those are some of the audiences for our reporting. I'm going to briefly mention list of issues reports. I mentioned that there's that overall cycle, and there is an opportunity for civil society organizations to submit reports earlier in the process than we are for these 3 countries at the list of issues or list of issues prior to reporting stage. And our goal at that stage, which is not the stage where we are right now for the 3 countries that are being reviewed, but our goal at that stage is really to say, hey, remember to include these issues on your menu of what you're going to talk about, include them in the list of issues or list of issues prior to reporting. So there is that opportunity at that earlier stage to just try to get your foot in the door and get the committee to say, oh yeah, we should ask about that. We should mention that we want to talk about that when the government sends a delegation to Geneva. But we're not talking about list of issues reports in any detail here, because all of the 3 teams that are working on reports for us for this time around are working on the next stage in the cycle, what we would call the alternative report stage. There are various names for these reports at this second part of the preparation cycle. They're called alternative reports, parallel reports, or shadow reports. It's all the same thing, they're just different names. So that's what we're going to spend a little bit more time talking about. Recall that the committee has this in-person constructive dialogue with the government of the state under review that lasts for about 6 hours. And then after that constructive dialogue, the committee publishes its concluding observations and recommendations. So our goal in submitting these reports before the constructive dialogue, our goals are to make sure that that constructive dialogue includes our issues, that the committee experts ask about our topics, and the government feels like it's on the hot seat when our issues come up, that yeah, these experts really care about these issues. It's like, oh, I didn't realize it was a big deal that we keep all of our people on death row in solitary confinement, but wow, the committee experts were really asking about that and were really concerned about that. So we want them to feel like they're in the hot seat with respect to our issues. And we want to make sure that our issues also get included in that final written document, the concluding observations and recommendations. We want to make sure that the experts are making recommendations that sort of align with what we've found and what the recommendations we think would be helpful for the country going forward to move toward abolition of the death penalty. So for all 3 countries that have upcoming deadlines, they're following the simplified reporting procedure, which means that we already have the LOI PR, the list of issues prior to reporting, from the Committee Against Torture. And we already have at step 2, we've already received the replies to the LOI PR that are the state party report. So we're between step 2 and step 3 in the process, and this is where our reports come in. And we're hoping to influence the concluding observations at step 4 and then lead to some follow-up for implementing those recommendations. So the key documents in our stage would be, of course, the treaty itself. But as I mentioned before, we don't need to quote back the treaty at the committee experts. They are very familiar with the treaty, but it's still an important context or background. Also, it's important context or background, but you don't need to sort of be quoting it in your report, are the concluding observations and follow-up from the previous review. That's kind of in the background, something the committee experts are aware of and would have included in the list of issues prior to reporting. Then the third item is one that is in the longer standard reporting procedures that we don't have here, which is the regular state party report. But then we have the list of issues prior to reporting. That's a key document for all of you. And then we have the state party response to the list of issues prior to reporting, which we have in all 3 cases. So how do we find these key documents? I've given you all a link to the session webpage. So this is the session that's going to be happening starting at the end of October. And yes, the deadlines are early. So here you see it's going to be the 81st session of the committee, and the dates of the session are there. And I mentioned that because you're going to put that information in your cover page. And you'll see that each country that's being reviewed has its own little flag and its own little set of documents that are available. So this is the page you go to for the session, and then each country being reviewed, this is where you can find the relevant documents for the upcoming session. And as you scroll down, these are the 3 countries that we're doing reports on. Oh, Need to admit someone. So Jordan, Kuwait, and Thailand are the 3 countries that we're working on reports for. And for each one, if you click the little plus sign, you'll find the list of issues prior to reporting from the Committee Against Torture, and then the state party report replying to the list of issues prior to reporting. You'll also find something called a Common Core document, which is usually a generic document about the overall legal system in the country. It's probably not relevant, but you're welcome to take a look to see if there's anything of relevance in that Common Core document. And you'll see under Thailand, there's already some information from civil society organizations for the LOIPR. There were some organizations that submitted reports earlier in that cycle. You can take a look at those. And then you'll also see for Thailand, there's a reprisal letter, which is unusual, but there was an instance in, I think, 2014 when Thailand had its previous review. There were reports that the government of Thailand was engaging in reprisals against someone who had done advocacy with the Committee Against Torture. They had received this information that this woman was facing harassment from the government. And so they received that information and they sent a very tersely worded letter to the authorities in Thailand saying, we've received this information, we would appreciate an immediate response. We're very concerned about this situation. And that is something that each of these treaty bodies has their own rapporteur or point person on reprisals. So if we hear from our partner organizations that are being harassed because they engaged in this kind of advocacy, we can alert the committee experts and they can sort of push back at the government. And even if the government doesn't reply, and there was no reply from the government of Thailand to that reprisal letter, it's just a way for the government to know that, hey, we're watching you, we're aware of the situation, and if anything happens to this person, we put you on notice that we are very concerned and we're going to be really, really we're going to sound the alarm if anything further happens to this person. So it's a good way to push back at the government when the government's trying to be a bully with respect to people who are engaging with the particular human rights body. For the treaty bodies, we have what we call a look-back period. And the look-back period for all of these cases is when the previous concluding observations came out. Now, for each country, it's a little bit different because they took a different amount of time between the different reviews. So for Jordan, the previous concluding observations were in 2015, Kuwait 2016, and Thailand 2014 when those reprisals happened. If a country hadn't ratified, had just ratified the treaty, we'd just look at the date of ratification, or if we had submitted a report earlier in the cycle, we'd just be doing an update from when we submitted that previous report. But for all 3 teams that are involved this time around, we're going to look back to when the previous concluding observations are. Now, that's really that's what technically is relevant. But of course, if you have 10 years to cover, you're going to focus your attention on things that have happened most recently in the past 2 to 3 years. That's going to be most relevant. That's what you're going to focus your time on. You're not going to dwell too much on what happened in 2016, 2017. The treaty body experts really want the freshest information that you can come up with. We've provided you with a template, and we will be adding the World Coalition Against the Death Penalty's logo and description to the cover page, but you'll enter in the country name, you'll enter in the session, change Human Rights Committee to Committee Against Torture, the months of the session, and we'll fill in the submitted date. But this is the cover page of the template that all the teams have received. And in terms of the substance of the report, this is sort of what you want to address. First of all, you want to provide recent or current information on our issues that might be of interest to the committee. Any issues, as we've talked about, that might touch on the death penalty. You also may want, depending on what the government says in its reply, in its state party report responding to the LOIPR, you can fact check them. If they're saying things that are incomplete, incorrect, or shading the truth regarding our issues, it doesn't have to be that we're not going to fact check everything in the government report. But if it relates to the death penalty or related issues, we may find some information that sheds a little bit more light on it, that the government didn't entirely cover the issues fairly. Or if the government just doesn't respond to a particular request for information that the committee had in its LOIPR, we can highlight that non-response. And then we're also going to propose recommendations or solutions. We want to be thinking forward to after the constructive dialogue, when the committee writes its concluding observations and recommendations, what recommendations do we want them to make on our issues? So we are going to propose at the end of our report, recommendations or solutions that we want the committee to make to the government. Some good practices for this report is, first of all, is framing your issues. So think about the recommendations on the front end. What recommendations do you want the committee experts to make? And use those recommendations to kind of frame your arguments and organize your report. Another good practice is to say, here's what the government position is, or it might be, here's what the committee asks, here's what the government says, or here's what the law says, and then here's what's actually happening on the ground. So like we are providing you with the great on the ground recent information that's going to be really helpful to the experts when they go into that constructive dialogue. You can also use examples or case studies to highlight problems that might exist in the particular country. So it might be that there are gaps in the law, places where the law doesn't fully respect human rights. One example is in the case of women who can be sentenced to death for murdering their abusers. If the country's self-defense defense, it only authorizes the use of self-defense when there's an imminent threat of bodily harm to the person who used lethal force. There can be a gap in the law because that would not apply to if a woman is a has long-term experience gender-based violence or domestic abuse at the hands of her abuser, and he is much bigger, stronger than she is. And so after repeated experiences of abuse, he's passed out drunk on the couch and she kills him. Then she can't raise self-defense as a defense because he was not conscious at the time that she killed him. So we could argue that that's a gap in the law that doesn't allow her to raise self-defense, but also in some countries, she can't even raise that in mitigation once she's been found guilty and being sentenced to death. That's a gap in the law that they don't allow her to bring that context of why she committed that crime to the court when the court is determining a sentence. There may also be barriers to implementation, and using sort of the same example, a barrier to implementation, even if the legal system allows bringing in evidence of mitigation that would sort of paint the context of prolonged domestic violence to warrant giving a woman a lesser sentence. If her defense counsel isn't trained on issues of gender-based violence and coercive control, he may not raise that information in mitigation when it's at the time of sentencing. So there could be a barrier to implementation, that there's a lack of education, a lack of training for defense counsel to raise those defenses. Those are just a couple of examples, though, but it can be quite valuable to use individual stories to highlight some issues that are happening in the country that are leading to violations of human rights. You don't need to provide a lengthy procedural history of the country's engagement with the Committee Against Torture or any other UN mechanisms. You don't have to say when they ratified the treaty or anything like that. You don't need to have a lengthy discussion of the substance of particular rights or the definition of torture or anything like that. Your audience knows this. We don't need to lecture to them. They know what the convention says. You don't need to present a lengthy legal analysis, just tell them what the facts are on the ground. And we also want to avoid making vague recommendations. So here we'll jump in and take a look at a recommendation. I think this is from an example that I gave all of the pro bono teams in a report that we submitted to the Committee Against Torture on Somalia and death penalty issues in Somalia. And you'll see, first of all, if you look at the heading, legal safeguards, due process, military courts, and the death penalty, and LOI, PR, paras. And then we give particular paragraphs in the LOI, PR that are relevant to what we're going to talk about next. And that's because the committee experts organize that constructive dialogue, those 6 hours, by paragraph of the LOI, PR. So we want to just signpost, here are the relevant paragraphs in the LOI PR and what we're talking about, because they will divvy up the different paragraphs among the different experts. So one expert is going to be the one that's focusing on paragraph 2. And so we will know, like, this tells them, if you're doing paragraph 2, read these paragraphs. This is our information. And then you'll see paragraph 5 gives a summary of what was in the list of issues prior to reporting, what information the committee asked for, requested clarification about. In paragraph 6, we give a summary of what Somalia's response was. Here's what Somalia says in response. They give this information, they assert this, and so on and so forth. And then starting with paragraph 7, we give our on-the-ground information. Authorities continue to impose death sentences, carry out death sentences. there were this many executions and so on and so forth. These new death sentences are handed down. It's from different judicial systems in Somalia, because Somalia has a pretty complicated federal system. And then in paragraph 8, we give a little bit more information. Sometimes executions happen within a few days of sentencing. So obviously there's no opportunity for appeal, which is one of the issues that we look out for. And so that's sort of the call and response structure that we use in our report. Now we'll jump ahead to general principles. We've talked about SMART recommendations, and before I jump into SMART recommendations, I need to get a screenshot of all the participants. So just give me a minute while I do that for record keeping purposes. Okay, now we're set. So SMART recommendations. Remember your audience. We're treaty body advocacy. Our primary audience is the experts. And the experts in the final outcome, they'll have some time and space to go into some detail in making the recommendations. If you're in the UPR training in the previous hour, they don't have a lot of time at all. They just have, maybe 90 seconds total to say everything. So the recommendations have to be pretty efficient. And for treaty bodies, the experts can go into a bit more detail in making the recommendation. They can mention specific provisions in law. They can just do a little bit more than they can in the UPR mechanism. And the recommendations are issued in writing. They're not delivered orally. So we can sort of have a little bit higher standards for what we want to come out of the process than in a situation where all the recommendations are issued orally in a bit of a time crunch. Another thing to think about with your recommendations is make sure to connect issues to solutions. A good practice that at least I like to do when I'm working on a report is, as I'm writing each section or each paragraph, I like to make sure that I come up with a recommendation or a solution for each problem I identify. Now, of course, with respect to the death penalty, abolishing the death penalty would resolve a lot of these problems, but I also like to think of what would be some recommendations that might be a little bit more incremental, that might be more likely to be adopted by the country that's being reviewed, and include those as sort of a running list of recommendations as I'm going through and writing my report. Another thing you can do if you don't do that, or if that approach doesn't work for you, is after you've drafted the body of your report, go through paragraph by paragraph and think, do we have recommendations that would address this issue? Do we have recommendations that would address this other issue? And just make sure that you have solutions or recommendations for each problem that you've identified in your report. We also want to make sure, and apologies if you've already been subjected to this acronym multiple times, we want to make sure our recommendations are SMART. We want to make sure that they're specific and that they specifically address the human rights violations we've identified in a report. We want to make sure that they're measurable. Will the committee be able to tell in 4 years' time, 6 years' time, whenever the next review is, will they be able to tell whether the state party has actually implemented what the committee said to do? Are they achievable? Is it something that can be accomplished over the course of 4 to 6 years? Is it something that we could reasonably expect, or is it just ensure that everyone has a fair trial? That's probably not reasonable to expect that to be accomplished if a country has fair trial issues, as all countries do. It's probably not reasonable to expect that all fair trial issues could go away in the course of 4 to 6 years. So we want to make sure that it's something more concrete that could be achieved over the next cycle. We want to make sure that it's relevant, that it actually addresses the human rights issues that we've identified, and it should be time bound. Generally speaking, the expectation is that it will be implemented by the time the next review happens, but we can also include shorter time frames. We could say, within the next 2 years, institute a formal moratorium on executions, for example. We can put stricter timelines in. There's nothing preventing that, but you don't always have to have a time-bound component to the recommendation, because there is this implicit assumption that it will get done by the time the next review happens. That doesn't always happen because governments don't actually, there's no law enforcement mechanism by which countries are required to implement all of the recommendations, but there is that expectation that they will at least make good efforts between the time the recommendations come out and when the next review happens. I want to say a little bit about working with partner organizations. We do have some partner organizations in the countries that are scheduled for this next review with reporting. And if your team has a partner organization, I'll put you in touch with them via email. And I highly recommend you be as diligent as possible in reaching out to the partner organizations. Some of them are very busy and just don't have the capacity, but others have would like to be included and may have really helpful information to share with you to include in the report. And they may have really good insights about what recommendations should be made that would be really helpful for their advocacy with their government and would help improve the work that they're doing on the ground. So it's really good to include them, to get information from them, to get their insights. And we also will want to share drafts of the report with our partner organizations. We typically, if they want, we will mention or name them as co-authors of the report. And if we have the chance to do lobbying in Geneva, we will make sure that if we have the opportunity to bring them to Geneva, we will let them take the floor and do the briefings with the treaty body experts. Or if we have the chance to submit video statements, we'll try to get our partner organizations to record those statements so it's their voices that can be heard rather than ours when that review happens. And I do want to say we go to Geneva at least once a year, sometimes multiple times a year. If we're able to go to Geneva, it's really a great opportunity for us to participate in these closed door sessions with the committee experts before they go into the review, because during those closed door sessions, they sometimes have really good, important questions that can give us a sense of what they're really focused on, what they're really concerned about. And it's our in-country partners who oftentimes have that information at their fingertips, can really give good case studies or examples of how things are, going badly or what some of the issues are. And that way the experts, when they take the floor to question the government, they're really well informed. And sometimes the governments are really caught off guard. Like, how did you know that? How did you know about what was happening? And it's because civil society did their homework and really did the job of preparing the committee experts to go into that room well equipped to hold the government's feet to the fire. And sometimes that can be really influential, that the government is like scrambling for a response and they're saying, wow, we really faced a lot of heat. We really faced a lot of pressure from those experts. We got to change something because we look really bad. Because these reviews, the 6-hour constructive dialogues, they're all live webcast as well. So media organizations can be watching online, civil society organizations that can't go to Geneva, they also can be watching online. And it can definitely make the news. It may seem strange in the United States to say, oh, wow, there's a lot of attention being paid to what's going on with the government review in Geneva. But in a lot of countries, this is huge news. And so any sort of gaffes, mishaps, or where the government is really raising important issues, that can make headlines in the home country and really can help to work toward change. It can help to say, hey, the international community isn't ignoring this issue. The international community is paying attention. And these experts at the UN are really being critical of our government for this practice, and the government say, yeah, we maybe need to make some changes. We opted to ratify this treaty, so I guess we need to do something more to implement our obligations under the treaty. So it can be really a helpful opportunity and a great experience for our partner organizations to, as I said, really let their voices be heard. And we are that mechanism by which their voices can be heard, that megaphone or microphone that really helps them be heard through the vehicle of advocacy with the experts at the Committee Against Torture. So that's what I have for you. The deadline for the teams that are currently working on those reports to the Committee Against Torture is September 4th, 2024. I am open to answer your questions. You have my email and telephone number up on the screen. You also have, and for those of you who are on the pro bono teams, I've already given you a link to our Chapter 9 on advocacy at the United Nations, which is part of a larger toolkit that the Advocates for Human Rights published called Human Rights Tools for a Changing World. That gives you, if you're better at receiving your information in written form, that's a great resource that you can refer to help you understand the context of the treaty embodying reporting process. So with 5 minutes to go, I am going to stop sharing my screen, and I'll be happy to answer questions or talk about anything further. You can use the chat, you can unmute yourself, whatever you think would be most helpful, and I am here to be of assistance. And I recognize a lot of you have a lot of materials to go through. I've sent you templates and checklists. I've also, for some of the teams at least, we've had an intern compile some initial background research. I know that there's at least one team that's still waiting for the intern to complete that work. I'll get that to you as soon as possible, but nothing should prevent you from doing your own research as well. The template gives you a lot of not the template, but the checklist gives you a lot of suggestions of sources to look for. So I really recommend you take a look at that template and use it as a guide for your research, because it points you in the direction of some really useful sources. One source that we find really helpful in a lot of contexts is the U.S. State Department reports on country conditions. Those State Department reports typically issued every April or May about conditions over the previous year. So you can look at the most recent, issued in 2024, but also the previous few years, to see what the U.S. State Department is flagging as important human rights issues in the country, and oftentimes issues related to torture and the death penalty, due process and fair trial rights, detention conditions. Those are often on the list, and our U.S. embassies around the world generally have really good access to information. They're often in close communication with civil society organizations in the country that feed information to them. So that can be a really good source of information that we can use in these reports to help identify information that we can't otherwise get at in other ways. Those State Department reports can be a big help. Oh, another thing I wanted to add, if you had the chance to attend the training on the Universal Periodic Review, I encourage you to take a look at your country's most recent Universal Periodic Review report of the working group, because that report might give you a sense of what the country's position is with respect to the death penalty. The government delegation will make a formal statement in the context of that UPR, which happened in the last 5 years, because it's a 5-year cycle. And that can give you a sense of how the government perceives the death penalty, how the government presents itself with respect to the death penalty. It might give you some ideas about recommendations to make that would address some of those issues. So that can be a good starting point if you're trying to suss out what positions the government takes with respect to the death penalty, so that we can approach our advocacy in a way that takes that into account. And if you don't have questions now, but come up with some as we go, you can certainly shoot me an email or give me a call. If you're not currently on a pro bono team and would like to be involved in pro bono activities reporting death penalty issues for the advocates in the future, please reach out to me or to our pro bono counsel, Teresa Dykoschek, who can help hook you up so you're on our mailing list when we have additional opportunities arise, because we do a lot of these reports over the course of a year. With that, if there aren't any further questions, I will wrap up. I want to thank you all for your time and attention. For those of you who are on pro bono teams, thank you very much for helping us with our advocacy. We really appreciate your work, and we look forward to seeing what you have for us as the results of your research and writing. So thank you very much, everyone, and have a wonderful afternoon.